Welcome to Dentons Privacy and Data Today. We're season 5, episode 8. And thank you for joining me. Jamie will not be joining us. She is still on secondment, but we'll be kicking it off in the new year. Don't forget, this is our second last one for 2025. We'll do another one in November, then everybody gets the December break. Let's see, what is in the news? Some odd, weird, and wonderful things in the news. Security cameras, home security cameras, not really relevant to businesses, but it's just a weird and wonderful thing. The BC Privacy Commissioner, like all the others, is announcing strategic priorities, which gives you an idea of where things are going to go. We've got a bunch of rumors swirling around a new federal privacy bill, so you heard it here first. I will give you some insights that I have. Whether they actually pan out is a whole other issue. Nova Scotia's overhauling its privacy regime. The chatbots, AI-enabled chatbot, and particularly chatbot companions, are the new hot thing. For recent decisions, we're going to discuss the TikTok investigation and what it means for organizations and children's privacy. You don't think you are collecting children's information, and you say you're not collecting children's information. You might even say you don't want children's information, but that doesn't mean you can escape the obligations that the Privacy Commissioner suggests you put in. And BC Court of Appeal weighs in on some privacy rights and reviews. And I'm also going to throw in a bonus one on CJEU, so an EU court decision that says pseudonymized information is okay in the hands of processors, and we'll talk a little more about that. All right, with that, let's kick this off. So I said weird and wonderful. Home security cameras, dash cams, but mostly home security cameras, smart doorbells with cameras. Everybody is getting one. They're the new hot thing. In most cases, these cameras are for personal use, and so they escape the application of privacy laws. Guidance for organizations exists, so the privacy commissioners have put out guidance that says you have to consider less intrusive alternatives, you have to have a clear purpose, you have to limit the viewing range, you have to put up signs, etc., etc. If you're not familiar with that as an organization, go take a look. But what's happening recently is there's a rise in consumer applications of this. Again, none of the stuff you hear from the privacy commissioners really applies to personal disputes. Usually when it comes up, it's neighbor disputes. Somebody aims a camera where they shouldn't and somebody else gets offended. And I did a quick search on Canly, and it happens a lot. Neighbors fight, who knew? Particularly about cameras. Typically, when it gets to court, the actions are framed in nuisance, intrusion upon seclusion, some Privacy Act claims in some provinces that have Privacy Acts. Something people may not be aware of is that municipal bylaws in some jurisdictions actually exist, and they look very similar to what the privacy laws would require. And recently, I think we're going to see lots more of this as these home surveillance devices proliferate. In Hamilton, Ontario, there was a man who decided he was going to put up 10 cameras on his property. Now, to be fair, he's had them there for apparently 7 years, and he regularly and voluntarily hands over footage to the police. He sometimes posts this to Instagram, some of the footage to Instagram, and that generated a complaint to the city, which apparently has a bylaw. And it prohibits residents from having surveillance devices that can view or listen beyond the perimeter of the land actually owned, leased, or rented by an occupant. So he was ordered to take them down. He's now appealing that. In Saskatoon, a neighbor aimed security cameras at neighboring family's backyard pool and recorded audio and video, including of children and teenage daughter and friends. Not surprisingly, the family was a little upset. That jurisdiction did not have bylaws with respect to cameras, so the family had to hire a lawyer to resolve that. So you can see this is starting to hit the courts as these sorts of devices proliferate. Now, the other interesting thing is many of these devices are now rolling out AI object detection or face detection or facial recognition. So keep an eye on this. It's going to get interesting. And a lot of these things, even though they're in the personal context, I expect there will be either municipal or provincial bylaws or laws that will be passed to address some of these things. Let's go on to regulatory and legislative updates. There's a fair bit. Now, as I sort of teased in the beginning here, there are rumors that a new privacy bill, this would be a federal privacy bill to replace PIPEDA, will be part of the budget, which is going to be tabled November 4th. Now, the budget is going to be primary focus on economic measures, not really surprising given what's going on in the world. But there are rumors from ISED and a few others that suggest there'll be an announcement of a federal privacy bill to replace PIPEDA. And if you recall, Bill C-27, formerly Bill C-11, both of those died. Bill C-27 got fairly far along. So I expect the new bill will look a lot like Bill C-27, but there's some rumors about things that will change. Now, just to be clear, there's no actual bill that's that I anticipate being introduced, probably not until early 2026. That's probably a little optimistic. What I'm hearing is that, if you recall, Bill C-27 mashed up privacy and AI. Those are going to be separate bills, according to the rumor mill. There will be fines and penalties, so no surprise that that hasn't been backtracked. And the expectation is that those may even be more robust. If you recall, under Bill C-27, it had this weird and wonderful arrangement where the privacy commissioner would make a recommendation for fines that would then be adopted or rejected by a tribunal. Apparently that is going away. It'll just be direct penalties and fines and orders levied by the privacy commissioner. It's not clear to me at this point whether there's an appeal mechanism or how that's going to work. More robust children's protections. The Bill C-27 sort of said, yeah, children are important. Let's make sure their information is sensitive. Govern yourself accordingly. Expect there to be more requirements around treating children's information. And this is pretty typical of what we're seeing globally. And we're going to discuss that in light of the TikTok decision a little later. More restrictions on, or more requirements on how consent is to be obtained, and the exceptions to consent are apparently going to be narrowed. And again, public information is going to be redefined. No surprises there, that was in Bill C-27. So we'll circulate a link at this point, not much more than rumor, but there is a link to the media advisory on the budget. So if you have nothing better to do and really like budgets, you can tune into that. You may have seen the dust up about the government's border bill, and this was in part introduced as a response to things going on south of the border. And there's been a lot of controversy about what this new border bill does. And of course, the tension is increased powers to intercept the information of individuals versus the privacy of those individuals. So their first shot at it was Bill C-2, and it had a warrantless data demand. So anyone who had a reasonable suspicion or reasonable belief that you had something they wanted, the border folks could then just ask you for things. They didn't need a warrant. They didn't need judicial authorization. So this was very, very controversial because it would make it easier for police to access Canadians' internet data without a warrant. So this is subscription data and so on. So that bill got, well, scrapped. Its revised bill is now Bill C-12. The lawful access provision got which this is the one that would have allowed the warrantless access to transmission data from online providers, etc. That has now been removed from this in hopes of getting it passed. Now, the minister has also said that he wants to have another crack at this and will probably introduce these things under a new bill. What does this mean? It's not just people at the border. Because it means warrantless access to a provider of any online service. So the police can show up, hey, I want your subscription and use your data. So that includes the telecoms, obviously, but it also includes things like dating sites, private contractors, therapists, any online service provider. And so that's really what's caused the anxiety here. Not surprisingly, the police chiefs, Canadian police chiefs, are really keen on this. Others are not keen. And just to give you some context, Canada is apparently the only Five Eyes member that doesn't have such powers. The powers differ amongst all of those. So keep an eye on that one. Over to Nova Scotia, we don't hear much about Nova Scotia, but they have now introduced the Freedom of Information and Protection of Privacy Act. They're basically overhauling their privacy regime. So they used to have two, an access regime and a privacy regime in the public sector. They are now going to mash those all together, and you get the Freedom of Information and Protection of Privacy Act, or FOIPOP, which sounds like some Korean boy band. This is the first attempt to modernize the province's access to information and privacy laws in about 25 years. Again, public sector. It combines what I mentioned. Interestingly, one of the things it combined, it mashed in there, was the previous Personal Information and International Disclosure Protection Act. Again, public sector stuff. Not many people know about this, but it essentially prohibited the movement of personal information outside of Canada. That appears to, even though the act is gone, the provisions have been transported over to FOIPOP. The exceptions to that are now found in regulations. So not surprisingly, this is more, they're moving away from the ombudsman model. They'll have a privacy commissioner. There'll be an independent officer of the legislature. So more consistent with what we see in other provinces. Municipalities and villages will now be subject to privacy oversight. The heavier fines, 50K for a corporation, which in this case would mostly be a municipal corporation or a village. The act, there's breathing room here, so it's not set to take effect until April 1st, 2027. So any of you that are doing contracting with public sector organizations in Nova Scotia may want to spend the weekend reading FOIPOP. Companion chatbots. This particular webinar is going to cover a whole bunch of weird things. And companion chatbots is one of them. There's been a flurry of regulation on this, or attempted regulation. So let's start with basic principles here. Just what the heck is a companion chatbot? Everyone's seen chatbots. That's the one where you ask, what are the hours of your store, and the pop-ups annoy you, and so on and so forth. A companion chatbot is different. These are AI-powered software, and they provide conversational interaction and emotional support, and they mimic a human-like relationship. So instead of your boyfriend, you can use your chatbot boyfriend. These things can be customized by users because it's AI. It learns from conversations. They become more personable, and they're marketed for things like companionship, emotional support. If you're a D&D role player, it can be used in that, or it could just be your, your new digital friend. So popular examples are replica AI and character AI. Some more advanced chatbots, they can also send proactive messages. So it's not you just reaching out and interacting. They can send selfies and participate in audio calls. They can suggest content and so on. And they can also, some are designed for specific roles. So they can be fitness coaches or homework assistants. And I use the term homework assistant advisedly there. The risk, of course, is there's a risk of emotional dependence in an unhealthy way, and manipulation and bias. As we've all heard, AI systems can hallucinate, and they also may contain biases from their training data, which is particularly risky for children. Interestingly, I would expect that senior citizens would be all over this, but I think there may be a technological barrier. So it's children, particularly post-COVID. Kids are apparently lonely, and they're really glomming onto these things. So with that background, California is leading, they're advancing a bill to regulate these companion chatbots. So focus is really children and other vulnerable users. The bill has been passed by the State Assembly and Senate, now heads to the governor's desk. The bill would require companies that operate chatbots marketed as companions to avoid exposing minors to sexual content, suicidal ideation, self-harm, or sexually explicit contact. Okay, nothing surprising there. It requires platforms to provide periodic alerts to users, reminding them that they're speaking to a chatbot and not a real person, and that they need to take a break. Annual reporting and transparency requirements would be established. Would also let individuals sue AI companies for alleged violations, seeking injunctions up to 1,000 per violation in damages and attorney's fees. So that's a class action cottage industry waiting to happen. California would be the first state to require these things if it was enacted. And if it was enacted, those core requirements would take effect on January 1st of 2026. And this just isn't a one-off. So if you've been paying attention to the FCC, they've actually launched an inquiry into these companion chatbots, and they issued a bunch of orders to 7 companies that provide these consumer-facing AI chatbots. And they're seeking information on how these firms measure, test, monitor, etc. The technology on children and teens is the focus. So a recurring theme, if you're not getting it, is children and teens. Children's information is important. And if you are sitting there right now thinking, hey, we don't collect children's information, that's great, but now you have to prove it. So if you're in the habit of just glossing over the children's information, news updates and privacy bulletins, you may want to start paying attention. Anyways, back to the FTC. The FTC inquiry is seeking to understand what steps companies are taking, or if they're taking any steps to evaluate the safety of their chatbots when they act as companions, to limit the product's use and potential negative effects on children and teens, and to apprise users and parents of the risks associated with the products. And I can tell you right now, I don't think anyone's putting anything out that says there's any risks. So the FTC report will take a little while, but it'll be interesting to see what they say. The FTC Trade Commission usually prefaces a bunch of class actions because these companies are now required to disclose a bunch of information and testimony. So I would expect to see some litigation around this. Over in the EU, slightly different focus, but again, chat. And so this is a proposed EU law, which is incredibly divisive. And what it would do is require those people that provide online communication. So this is just isn't companion chatbot, it's online communications generally to keep kids safe. There you go, there's that children's privacy thing again. And the idea is focused on keep kids safe from online sexual predators. Now, some of the EU member states are on board, others have been very concerned about the privacy rights. And so if you're going to Google this, it's the Regulation to Prevent and Combat Child Sexual Abuse, or the CSAR abuse regulation, and in common parlance, it's known as chat control. And so let me give you an example of what this is intended to stop. So imagine there's a little girl, she's lonely, she's 11 or 12, she's looking for friends online, and she begins chatting to someone online. Turns out to be a nice, friendly man. She is under the impression this is someone who cares about her and his friend. Then he threatens to cut off contact unless she sends him pictures of herself naked. And then the usual extortion. He threatens to disclose them to families, etc., or schoolmates. So that's what this is intended to prevent. And apparently there's been a big rise in this. So under the proposal, that it would require tech firms deemed to be high risk, so this is pretty much any of the social media platforms, they may be ordered to scan all links, images, and videos, though not text themselves, that are shared on their platforms and report instances of suspected child sexual abuse material to law enforcement. Most controversially, these rules would apply to content shared on messengers such as WhatsApp, which use encryption, so they'd have to have a way to scan all this. Some states are on board, other member states have balked, including Germany. They just think this is an unprecedented privacy overreach. So this has been delayed and political machinations are happening there. The reason why this matters is because what happens in the EU generally starts happening here. We've seen that with children's privacy. We are now starting to see this with online monitoring technologies. Back to Canada, and this time we've gone from Nova Scotia, we're going to the other end of the country, over to BC. So the BC Privacy Commissioner has announced a strategic plan. All the privacy commissioners do this. It's usually whatever they're going to focus on in the next 3 or sometimes 5 years. The strategic plan for the BC Privacy Commissioner goes up to 2028, and he's labeled it Trust in the Age of Information. So the strategic plan comes out of a year or more long series of consultations, some formal, some informal. And the Privacy Commissioner in this in the report notes that these consultations identified some significant areas of unease. And I'm sure many of you are already feeling these topics. Number one, there's unease over AI. People seem to think it shows great promise, but sense the technology may be slipping out of our control. A lot of unease around children's privacy online and the exploitation of children. And a surprise one, and the Privacy Commissioner even mentioned this, he didn't see this one coming, but it was on video surveillance. So the increase in social disorder sort of post-COVID is leading to increased surveillance as a solution. And so we're right back to where we started, more cameras, more surveillance measures. So the nice language is that his strategic plan tends to support organizations in adopting privacy-aware approaches to these issues. That sounds very lovely. But then there's a sentence in there, over the next 3 years, the BC Privacy Commissioner will prioritize initiatives, investigations, education, and enforcement actions that align with the strategic priorities set out in this document. So if you are in BC, you may want to take a look at where your CCTV cameras are pointed and whether or not they're using AI or capturing biometrics. We're seeing a huge jump in that. If you collect or purport not to collect children's privacy, you'll want to take a look. And if you're using AI, particularly in consumer-facing applications, you might want to take another look at that. So expect some enforcement actions in that area. BC Privacy Commissioner doesn't have a lot in the way of powers at the moment, but they usually team up with the Federal Privacy Commissioner to help with that. All right, over to jurisprudence. So what happened in the courts or in the Privacy Commissioner enforcement area? So the number one top that you've probably been reading about is the OPC, Federal Privacy Commissioner, had issued its finding into its investigation into TikTok. And this caught a lot of attention. It wasn't really a surprise. The social media platform has been the subject of investigations in multiple jurisdictions and has been told to basically put in additional protections for children. Again, that children theme again. So it was kind of a foregone conclusion. This was really the Privacy Commissioner using an opportunity to telegraph to the rest of Canada how it's viewing children's privacy and what it expects. And that's really the meat of this decision. It's quite surprising. So what the Privacy Commissioner looked into were two things. It wanted to know whether the platform's collection, use, and disclosure of personal information for the purposes of ad targeting and content personalization on the platform, particular focus on TikTok's practices as they related to children. So considered whether the company engaged in these practices for a purpose that a reasonable person would consider appropriate in the circumstances, or the appropriate purposes test, and whether they obtained valid and meaningful consent. Not surprisingly, it found TikTok did not do either. So it found inadequate measures to keep children off TikTok. Now, remember, this is not that it mismanaged information. This was about keeping children off the platform. So its terms of use, pretty standard, it's probably in your own, prohibit users under the age of 13 or 14 in Quebec from using the platform. But it wasn't just enough to say that. The Privacy Commissioner found that there were inadequate measures to keep kids off the platform. And these are children. We're not talking about youth. We're talking under 13, under 14. And so as a result, it had collected the sensitive information of many children, and they'd used that for ad targeting and content recommendation. And so what the Privacy Commissioner noted that there were more robust provisions to keep kids off the platform's live feed and other sort of more in live streaming functions and things like that. And so the platform uses facial analytics to prevent under 18 users from using the live stream function. And the Privacy Commissioner seems to suggest that companies need to roll out facial analytics to screen out under 13s or under 14s in Quebec. Which is a bit interesting, particularly since even on the heels of that, the Privacy Commissioner did not like how the platform was handling biometric information. The other one was valid and meaningful consent. No surprise there. It found that the policies were long. They were not adapted to youth. They were not explicit enough, not detailed enough. They weren't available in French, and so on and so forth. One of the things that they said was that even though TikTok did take steps to prevent advertisers from using certain sensitive categories of information to target users, the commissioner found that when taken together, so this is if you have a big profile, the personal information collected and used via tracking and profiling may be sensitive. So this is the idea: at a certain point when you have a comprehensive profile, it becomes sensitive, which then kicks you over into a requirement for express consent. It also found, because TikTok was using some biometric information for facial and voice analytics, it found it had not met the criteria for that. And then it had a bunch of recommendations. The company was required to implement 3 new enhanced age assurance mechanisms that are demonstrably effective at keeping underage users off the platform. So this is a warning to companies. If you are saying you do not knowingly collect the information of children under the age of X, then you'd better have something more than that casual reference in your privacy policy. The expectation from the Privacy Commissioner is that you're actually doing something about that. Now, if you're an auto dealership, you might be able to get away with the note in the privacy policy and then removing information when it comes to your attention. But if you are using something that's more available to children, like social media, then you probably are going to have to do something more than just put in that language. The Privacy Commissioner seems to suggest that age gating and age verification measures, such as facial recognition or facial detection, are the accepted standard here, which is troubling. And a lot of people have pointed out that that is not a great idea to collect that sensitive information of children. So, and we saw that just with the Discord data breach that uses some sort of that form of age verification, and they over-collected the biometric information. It was subject to a breach. They were also to cease allowing advertisers to target under 18 users except via generic categories such as language or approximate location. This is a sea change in targeted advertising. So you may want to pay attention to how your targeted ad programs and the vendors you use are actually slicing and dicing your information. For teens, they had to publish a plain language summary of their privacy policy, centralize the privacy settings, and a few other things like that. So one of the main things I get pushback on with my clients is, do we really have to do that? Do we really have to post summaries? Do we have to centralize our privacy? Do we really have to make it that easy for people? The message from the Privacy Commissioner here is pretty clear. Yeah, you do, particularly where under 18s are concerned. So if you do not have a scheduled overhaul of your privacy settings, privacy program, consent practices, you may want to take a look at that in the next few years. Because as I mentioned, circling back to that, the possibility of a new federal privacy bill that has fines and penalties, the children's privacy piece is going to be a big one. And then I mentioned a decision out of the European Union, the Court of Justice of the European Union. This is CJEU. They confirmed that pseudonymized data, so remember, this isn't anonymized, this is just direct identifier stripped out. Pseudonymized data will not be personal data in all cases. So normally pseudonymized data, because you can re-identify it, is personal data. It's considered to be a safeguard. So the CJEU made the sensible decision that in the hands of a controller, so if the controller pseudonymizes the data, it will be personal information. Why? Because they have all of the other data sets and other information that they can re-identify it. However, when they hand it off to a service provider, or in GDPR speak, a processor, it may well not be identifiable. And this is important because one of the big problems has been companies trying to pseudonymize data and ship it over to controllers for processors for processing for things like AI data training and so on and so forth. So the takeaway here is that if you have appropriate controls in place and you've done this with appropriate safeguards and technical controls, then in the hands of a processor and the technical and organizational measures may have the effect that the information is not personal in the processor's hands if the processor is unable to re-identify the data subject. So that is a very good common sense approach to things. So it remains to be seen how Canada approaches this. Hopefully they will adopt a similar thing. All right, we are at time. Thank you to everyone. As usual, a recording of the session will be sent out in the coming weeks. Just a reminder that Dentons Data Summit is on November 5th. We have a couple of workshops, one on biometrics in the retail context and one on children's privacy. If you haven't already noticed, children's privacy is a big deal. And we will see you again November 19th, which will be our last webinar for 2025. Thanks, everyone.